Okay, thank you so much.
Thank you.
Okay, up next we have on Zoom a former colleague of mine and longtime friend, Jay Kaplan, representing the ACLU of Michigan.
Good afternoon. This is indeed a special day and my heart is full. I'd like to thank Chairwoman Chang for holding this hearing on amending our state civil rights laws. My name is Jay Kaplan and I am the staff attorney for the ACLU of Michigan's LGBTQ plus project. And I've served in this position for the past 22 years. During this period of time, and even a decade before I started my job, we have seen efforts each legislative session to amend Elliott-Larsen to explicitly add the categories of sexual orientation and gender identity and gender expression in order to provide comprehensive civil rights protections against discrimination for LGBTQ people. In almost every previous session where the bill was introduced, it was denied a committee hearing so that it could not move forward to become law. And yet during these past 22 years, the ACLU of Michigan, as Senator Moss mentioned, has received more than several hundred complaints of discrimination against the LGBTQ community in almost every facet of life, including discrimination in employment, housing, education, access to health care, and other public accommodations. One such person was Amy Stevens, a transgender woman who was fired from her job at the Harris Funeral Home when she shared this fact with her employer. We took Amy's case all the way up to the United States Supreme Court, which held in Bostock versus Clayton County that employment discrimination based on gay or transgender status is discrimination in violation of federal civil rights laws prohibiting sex discrimination. Unfortunately, Amy didn't live to read this legal opinion, but her case left a legacy for the LGBTQ civil rights community. Last year, the Michigan Supreme Court applied the Bostock decision to Elliott-Larsen civil rights laws in the case of Rauch World versus Michigan Department of Civil Rights, holding that LGBTQ people are protected against employment, housing, education, and public accommodations discrimination on the basis of sex. So why do we need to amend ELCRA to explicitly include sexual orientation and gender identity and expression when we already have the Rauch World decision? We need to do so to both cement and codify the Rauch World decision. So LGBTQ rights can never be up for question or interpretation by a state court. With a law in place that explicitly mandates that LGBTQ people are to be treated with dignity and fairness under ELCRA's umbrella, a negative court ruling in the future cannot wipe out important progress that has been made. The time to amend ELCRA to include LGBTQ people in its protections has been a long time coming, and it's been a long time overdue. And the time to do this is now. Thank you.
Thank you so much, Mr. Kaplan. Any questions from committee members? All right. Well, thank you again. And next we have Donna Stevens on Zoom.
Good afternoon.